Amanda Conley and Shabnam Malek. That's Brand and Branch, intellectual property lawyers from San Francisco, from the Bay Area. They take us through, their backgrounds, of course, and they do give us a few pointers. As far as IP in cannabis, I'm Seth Adler, your host of the Cannabis Economy podcast. Thank you for listening. Really enjoy talking to these two strong women, Brand and Branch. All right, so here's Brand, and here's Branch, and here's Amanda, and here's Shabnam. I guess which one's Brand and which one's Branch?
Depends on the day.
Yeah, it really does depend on the day. I'm feeling a little more Brand today, I'll be honest.
Okay, and that's Shabnam, if I'm not mistaken.
No, that was
Amanda.
Oh, that was Amanda. This is going to be very difficult. Intellectual property, legal services. Obviously, this is an industry that needs lawyers. So thanks. You guys have your own point of view there in California. How's old AB 266 going for you?
We like to say MRSA because that's attractive. It's exciting. We have been seeing a lot of cultivators come out of the woodwork, out of the woods, literally, getting ready to pay their taxes and form an entity and all that stuff they do with the other lawyers. And then they come to us and they say, hey, I realize that my brand is important and it needs protecting. And we're really excited to help them with that. I mean, that's been one of the biggest changes we've seen since the new legislation came down.
Totally. And so does that kind of start to explain the name? Why don't you take a minute and tell us why? I mean, it's very catchy.
Well, it's funny. We spend a lot of time evaluating our clients' names, their brands, and we had never, at least I hadn't, I don't know if Shabnam had herself, but I had not had the experience of picking a brand myself. And so when we decided to start our own firm, we really developed more empathy for our clients than we had ever had before. We realized, wow, it's actually really, really difficult to pick a name that you like and doesn't have associations you're trying to avoid and is available, isn't already used by someone else. And so we toyed with a lot of different names. We kept sending things around to friends and family for their thoughts, which was helpful, but also somewhat depressing. And we were compelled by the sort of ampersand in the name, but not using our last names. We thought that was kind of a fun formulation. And, we eventually stumbled on this because we liked the idea of we help you brand and then we help you grow, or we help you protect your brand. We're not going to come up with it. But, we liked the focus both on branding, the legal aspect of what we focus on primarily, and then growing, because we really like to work with companies who aren't just, coming in to clear a trademark, but actually coming in to grow and wanting us to help them with their holistic growth strategy.
Okay, so how much of a double entendre, Shabnam, is the grow? Because as I understand it, you are focused on cannabis.
We that cannabis represents a primary part of our practice, or a prominent part of our practice, I should say. But we're kind of trying to play on that, right? Branch, grow, and what that means for the cannabis industry. But I think really our focus has been on what that means for what we do for our cannabis clients, which means we help their businesses grow, whether it's growing within the state, whether it's growing out of state. But yeah, I mean, that wasn't lost on us. We had some other ideas in the mill initially that were a little bit more blatant than that, but we like the subtle entendre in Brand and Branch as it relates to the cannabis industry.
Got it. Okay, fantastic. I'm happy to hear you say Brand and Branch as opposed to Brand and Branch. But you are originally from another part of the world, Shabnam. Where are you from?
I am. I'm Iranian. I was born in Iran, and my family came to the United States in the late 70s, right around the time of the revolution and then subsequently war with Iraq. But I've pretty much been raised in the United States, mostly in California. I hold on to my identity, my Iranian identity, my Iranian nationality.
When I first met people like you, and I mean folks that emigrated in the late 70s to the United States, I was introduced to those folks. They said they were Persian. You say you're Iranian.
Right. That's really interesting. My opinion on the matter has never been on record. Should I go on record?
I think you should, because
I feel like if not now, when?
This is breaking news. You should include this in your press release. Yeah, exactly. For the first time ever, Shabnam Malek goes on record about her opinion of Persian versus Iranian. I call myself Iranian because I was born in Iran. I'm an Iranian national, and that is my identity. That's my place of origin. My ethnicity, I think, is Persian. The food that I eat is Persian. My name is Persian. But when somebody asks me where I'm from, or even if they ask me what my ethnicity is, often I actually say I'm Iranian. I think that a lot of people in the United States, for a couple of different reasons. One primary reason, depending on the time when they immigrated, call themselves Persian to sort of dumb it down for Americans, to stay away from a lot of the stereotypes associated with Iranian. Persian, sounds beautiful and flowery, and Persian history and Persian music and Persian Empire, it's all very lovely and palatable, whereas Iranian is often associated with terrorism and, the Islamic State and things of that nature, the Islamic government. But I do think that there's a lot of people who have a legitimate claim to the word Persian because they are ethnically Persian. They weren't born in Iran. In fact, I have several friends who are ethnically Persian, sort of the truest form of what the word Persian might mean for them. And that's fair. At the end of the day, I don't begrudge anybody whatever the word they want to use to identify themselves, whether it's their ethnicity or whatever other features of themselves they want to use or name they want to use to describe a part of themselves. But for me, it's really important that I not sort of make this any easier for anybody to understand. I'm Iranian.
No, I get it. I mean, I was born in America. I was born in New York. But if you ask me how I identify, anybody that I've spoken to before can tell you that I say that I'm Jewish, and if you look at me, you would say that I was good looking. So
I thought that's what you were going to say.
Yeah. Right, exactly.
Yeah. No, but I kind of get where you're coming from. But I guess why not? Let's take the opportunity. It's here in January 2016. What's your sense, to put you on the spot, of what's going on currently with Iran? It seems to be always a hotbed of information and activity.
Yeah, it's very interesting what's going on with Iran. I think that on what subject? There's so many different things going on with Iran right now. My parents actually just came back from Iran a few weeks ago, and we talk all the time about, sort of what's new and what's new in Iran vis-a-vis relations with America, what's new in Iran vis-a-vis relations with the rest of the Middle East. And it's thorny. There's a lot of things going on in Iran. If you're thinking about, is regime change imminent? No, we are not going to see regime change in Iran. Is a warmth of relations with the United States imminent? Maybe, except for there's this whole visa issue that's come up in a House bill recently that sort of chilled a lot of Iranians and the Iranian government in some respects. There's always a lot going on in Iran. Iran is a really important socio-political player in the Middle East, and they can't be ignored. And I think that's why the United States has had this ongoing, sort of love-hate relationship with Iran, because they need them. They could potentially be an ally, but obviously right now they're not. They're identified as an enemy, one of the three primary enemies in that region. And it's unfortunate. I think there could be a lot of benefit to warming of relations between Iran and the United States. On the other hand, a lot of people believe that the closer the current Iranian government and the United States become in political relations, the more likely it is that the current regime in Iran will remain in power. And so, there's that rub. But it's tough. Regime change is tough. I don't think we're going to see an Arab Spring in Iran anytime soon.
Interesting. So, Amanda, your whole thing is so last year, you and I talked about the fact that with Melissa Etheridge, we talked about the kind of the storylines of gay marriage and cannabis legalization kind of running parallel. Obviously, gay marriage has won as far as timeline is concerned. But what are your thoughts on the congruency of the two issues?
Yeah, gay marriage has won in terms of timeline recently, but it's sure been a long fight. I mean, Melissa Etheridge is in both, so that's one. But no, it is funny. I didn't expect to see the parallels immediately. Maybe I should have. But one of the first industry, conferences or seminars or something I went to, I was just hearing rhetoric that really reminded me of, conversations I've heard at LGBT, meetings, fundraisers, things like that. The sort of, we need to work together. We need to show people that they don't need to be afraid of us. We're an oppressed group, but we understand each other and we are supporting each other for progressive change. And it was just surprising to me to hear that rhetoric in the context of an industry event too. I both Shabnam and I have been intellectual property lawyers long before we were cannabis intellectual property lawyers, and I mean, certainly speaking for myself, I've never gone to an industry event outside of cannabis where I've thought, oh, wow, look at this political change we're all making and look at us coming together and, being progressive. And that's very, very unique to the industry. And so, yeah, I mean, the parallels are striking. I think both have seen a substantial increase in support as of late, in part because I think, the way that media and political media and personal and political views are disseminated now, that dissemination is more rapid, and perhaps as a result, the change itself and the changing perspectives in the country are more rapid as well. So, yeah, I mean, I'm certainly not the only one to identify those parallels, but I am consistently struck by it. And, it's nice to be a lesbian cannabis lawyer, sort of have a foot in both worlds.
Well, I mean, most people now like 2 out of 3 of those things.
Cannabis and lesbians.
Yeah, the lesbians and the cannabis, and the only issue is, the profession that you've chosen.
And that's how I temper it. I don't want to be too appealing to anyone, and so I figured,
right.
Become a lawyer, you'll kind of undercut the value of the other two. Exactly.
What if you were like a celebrity chef? It would be too much.
Oh my God. I mean, it wouldn't be fair to other people, quite frankly.
So where did you grow up? Shabnam said she grew up in California for the most part after she came over, but where did you grow up?
I grew up in Wisconsin.
Oh my God! All right, so go Packers, I guess.
Yeah, I guess. I'm a little more of a
Do
Bears.
you care?
I'm a Bears fan if I have to pick. I grew up basically on the border of Illinois and Wisconsin, and I'm not sure why, but I always had more of an allegiance to Illinois, and that's where I went to college, just a small liberal arts school in Illinois. But I'm not a big fan of Wisconsin teams, I'll be honest. But I'm not a big fan of sports in general, so that's not saying that much.
Okay, fair enough. And then where is so you go from kind of the border of Wisconsin to Illinois into Illinois for school, small liberal arts college. When does law come into it? When does California come into it?
Much later. I started school planning to be an elementary school teacher, so a little bit of a change since then. I ended up switching to psychology, and I planned to go to grad school in psych. But as I looked into that, I found that I wasn't so interested in pathologizing or even fixing people as I was just kind of studying what makes them tick. And so at that time, I moved over to sociology. I moved to Boulder, Colorado, which turned out to be very useful in my current profession. But I went to the University of Colorado, to CU, in Boulder for 3 years. I was in a PhD program for sociology, and I just... the more I learned, the less certain I was that I wanted to sort of be in a tiny corner of academia in my ivory tower talking to myself and one other person. And I had taken the LSAT, the test you take to go to law school, about 5 years prior. Well, I should say 3 years in, I started rethinking things. And I had taken the LSAT 5 years ago. And I had taken it because I had this dream long ago of being like a psychologist / policy wonk, where I would be in the trenches meeting people who needed policy change, and then I could inform policy change. And it was a really, noble idea. And I took the LSAT, and I actually liked the LSAT. But then I was like, wait, I don't want to go to law school. That sounds horrible. So there I was in grad school, not sure it was the right fit. I had one more semester I could use that LSAT score, and I thought, you know what, I'm going to do it. Same time, I met my now wife, and she was in Colorado but was thinking about moving to New York, and I said, I'd like to move to New York with you, but I can't just move with a girlfriend. I have to find something to do. And so I decided I'd move to New York and go to law school. And that's what I did. And then I loved New York, but I knew I was going to leave law school and become a big firm lawyer, at least at first. And I could not imagine working in a stressful big firm in Midtown Manhattan. So I discovered that San Francisco was the perfect spot of lots and lots of lawyers, but a good lifestyle. So I convinced my still then girlfriend, but that wasn't our fault, that was the laws, to come out here with me. And so we moved to California, I guess about 5 or 6 years ago now, and I cannot ever imagine leaving the Bay Area. It's fantastic.
So I would imagine you're a fan of Gavin Newsom.
Yeah, I'd say I'm a fan.
Well, I mean, isn't he... Does that, am I right with how the, speaking of timeline again, lines up as far as you and then being able to get married out in California? Wasn't he a...
He wasn't. He was earlier. So for us, it was okay. Strange. So we were in New York when we got engaged, and we moved about a year later, and about 2 months after we moved, New York started allowing gay marriage. And then we moved to California when Prop 8 had gone through, and so we had lost the right to marry here. We left a state where we would have had the right to go to the state where we always should have had the right, but didn't. And right. So we got married after Prop 8 was overturned at the Supreme Court in 2012. When did we get married? 2013? This is on the record.
You were at
No, I got married in
2013.
Yeah, it was right after it was overturned, so about 2 months after. Yeah, I'm sure my wife will never listen to this. It's fine.
So Gavin Newsom, when he was the mayor of San Francisco, that was way back.
That was before, exactly. Yeah, so he was the one who legalized it in the first place, or, he was the reason that it was legal in the first place, but then Prop 8 took that away, and then we came during that time.
All right, so now you're in California. I got it. Back to Shabnam. Now, where, you're in California, when does law come into it for you?
When I went to law school and not a minute earlier.
Shabnam, that's, thanks. What we need is a little bit more. Well, when I went to law school and then when I graduated and passed the bar, I became a lawyer.
There was no, I'm going to be a lawyer. I dreamt of being a lawyer. I wanted to be a lawyer or any of that.
There was none of that.
Look, my LSAT score that I randomly took one year is about to expire. I may as well go to law school. And have you seen the meme on Facebook that's like Iranian families? Actually, it probably says Persian. It's like Iranian families, lawyer, doctor, engineer, loser. And so even though I was a gainfully employed professional and an ancillary to the tech industry job with a perfectly legitimate bachelor's degree, I felt the calling of graduate school like every self-respecting Iranian does. And, I'd taken that LSAT, so I was looking at law school. I wasn't going to be a physician, so that, and I don't have the brains to be an engineer, so that left lawyer out of the 3 careers an Iranian may pursue. And so here I am. So
this is a familial cultural calling, that it was going to be one of these things, and I had already taken the LSAT, so fine.
Right. Definitely graduate school was a familial cultural calling. I'm a modern day Iranian, so any graduate school would have probably done, but this was it. I had taken the exam.
You said you were in tech before? What were you doing?
I was in an ancillary industry to technology. I planned technology events. So these conferences, one of them, the biggest one that I worked on was called Software Development. So they were like 5-day conference and expos that trained developers and architects on, whatever it was back in the early aughts that they needed to know. So I was technically really an event planner, a content director, but I did it for the technology industry.
Got it. Okay, and then you went to law school. Did you go to law school? Where did you go to law school?
I went to law school in San Francisco at University of San Francisco, where I also went to undergrad. I lived like within the same 5-block region of myself for, since I came up here for undergrad, actually.
Huh. Can you explain to us the Socratic method?
I think you're
I think you
demonstrating
just did,
yeah. Yeah, can you, Shabnam?
Yeah, no, exactly. Yeah. Can you? You, second seat from the left, with short blonde hair.
It's terrifying.
Yeah, Conley, can you tell me what Mr. Adler's talking about right now when he says, can you explain the Socratic method?
I mean, is that just is it just shitting on people? Is that what we're to understand?
I think it's a compelling method of learning and engaging dialogue. And I was one of those really nerdy, super into it law students. So I didn't even wait to be called on, frankly. I was like hands raised, asking dumb questions, making smart answers, making dumb answers. Like I was into that. I thought, I love to process. I like to talk. I really liked it. I thought it was actually an engaging way of learning. And I have since then, I helped my former boss lead a trademark law/practitioners class at USF last semester or 2 semesters ago. And I since then learned how hard it really is to engage a classroom and to run a classroom using the Socratic method. I think it's, if you do it well and you know what you're doing and you know the right kinds of questions to ask to pull information out of people, you can create a really engaging dialogue. So I was into it. I didn't have like a computer in front of me, texting and looking at the internet and being irritated when I was called on. I was like, had done the reading probably twice, excited to be there, sitting in the second row. I was into it. I wished that I would be called on more in law school. That's how into it I was. So you're not going to hear any complaints from me.
Well, I'm sure that they saw that, and I'm sure that's why the you being picked was tempered.
Yes, how did you know?
If you're gonna come that prepared, Shabnam,
exactly. It's always that way, right? The one who's excited and prepared is the one not called on because the professor's like, "We've heard enough out of you." Mm-hmm.
Yeah. So if Shabnam is literally only second row, so that she's not, actually sitting in the front row and uber prepared and beaming in the face waiting to be called, Amanda, are you cut from the same cloth, or is there a little yin and yang in there?
It's interesting because there is a little yin and yang, but the really funny part is I think we've now switched.
Yes.
Like now yes, I was terrified. I was often underprepared. I was always online shopping. And but now I think if you gave those characterizations and asked someone we know to match them to the people, they would be shocked at how this would play out. So my most terrifying class was civil procedure, my first semester. There was a book written that Shabnam knows, you may know, called 1L, like your first year of law school. And it was written by Scott Turow, and it was written about his horrible, terrifying experience at Harvard with his civil procedure professor, Arthur Miller, not the playwright. And Arthur Miller had left Harvard by the time I got to law school. He was like 80, and he'd come to NYU Law, where I was. And so he was my civil procedure professor, literally the guy that the terrifying book was written about. So I was very prepared. 1L year, I was pretty prepared. The story for me is that I was uber perfectionist my entire life, and so I let off a little in law school, and Shabnam was sort of the reverse. But yeah, I was uber prepared. Arthur Miller was terrifying, and he would basically he would pick you randomly. You never knew when it was coming, and he would say, basically, tell me what is the case about. Or he would ask one question, and you would be expected to just talk and talk and talk and talk.
That's like my dream professor.
Oh, my God. Until he either interrupted you to cut you off and move on to someone else, which meant you failed, or kept asking questions, which meant you were on the right track. And I recall being on for about 30 to 40 minutes in his class and it being one of the most terrifying experiences of my life. So, yeah, I was not a huge fan of the Socratic method. I think modified versions of the Socratic method are great. I care a lot about pedagogy. I was teaching, as I said, I wanted to be a teacher much of my life, and I did teach some undergrad courses when I was in graduate school. And so I did get frustrated with law professors who didn't, who kind of did the, like, I'm going to ask you a question and I have an answer in my head and I'm just going to try to get you to guess the answer that's in my head. The Socratic method is better than that, but man, was Arthur Miller terrifying.
Did anybody make that connection between Arthur Miller and Arthur Miller, or was that not welcome?
Oh, well, not to his face, but I recall that early on before class started, of course, everyone knew that they were going to be in this section. They had Arthur Miller, and I think I remember seeing a Facebook thread or something that, people had come together to talk about this in advance, and everyone was bemoaning that we had Arthur Miller, and someone said, oh, come on, guys, Death of a Salesman wasn't that bad.
I love it. I'm also a very big fan of that specific play, Death of a Salesman, but that's besides the point. I mean, we don't have to talk about Biff or Happy during this conversation, but you did just bring up Facebook, and let's actually talk a little shop here. I would imagine, intellectual property here in the 21st century with your Facebook and your Twitter and your Instagram and whatever else you're dealing with. Is it easier? Is it more difficult? Easier because there are more ways to prove, what you're doing. More difficult because there are more ways to prove what you're doing.
Good question.
That is a good question.
I mean, one thing that's hard when we do a search to see if a trademark is available, and you'll see like a Facebook page that someone has started using, whatever, garden cannabis brand or something. That would be a terrible brand, but I'm using it because I can't think of anyone using it. And let's say you come across their Facebook page, right? It doesn't take anything to launch a Facebook page, and it takes a little more to launch a website, although less and less now, and it takes a lot more to launch an actual business. But the Facebook page, you just never know what to make of that. You never know, okay, well, is, garden cannabis actually a robust entity that's going to sue me if I try to use this name? Or is it some dude that got high and bought this, or not even bought, registered this Facebook page because he thought, oh, that's a good idea, and now he's been posting photos on it. So that makes it a little tougher. It is easier to find evidence of use and things like that we need to submit in disputes. But I'm thinking of the issue that we had at our last firm.
I was totally thinking of that too.
We had a client at our last firm who was selling, this was not cannabis, she was selling or offering a service having to do with wish lists, and she had us do a search, and all we had found is one Facebook page. They had a landing page. They had no use yet. They had nothing. And, we said, look, this is fine. This is probably not a big deal. Here's the risk. But, they haven't actually started using the mark yet. Well, turns out the father of the person who had not started using the mark is a lawyer. Not a trademark lawyer, a state real estate lawyer, but you better believe that the minute we filed the trademark application, the people on that Facebook page came after us, and they didn't have prior rights, but they made our life a living nightmare for a period of time. And that's the trouble. It's really hard to know what's behind the internet, what's behind, the pages you see on social media.
It's amazing. What are some basic principles for, there's a lot of entrepreneurs that listen that are, have businesses either established or getting established. What are some kind of basic principles of your digital brand presence to keep in mind in terms of intellectual property?
Well, I'd say the first thing is that just because a domain is available doesn't mean the trademark is available for use. And on the other side of that, just because a domain isn't available, it doesn't mean you're not going to be able to build a company around a certain brand. You might have to be creative with your domain name. The same thing goes for Twitter handle, Facebook page, all that. If it just because something is available or you throw an S on the end of something, it doesn't mean that all of a sudden now that trademark is available. I'd say, again, you have to be cautious when you identify uses of similar marks on social media sites. You have to be cautious. It's hard to know how extensive that use may or may not be, and you should consult a lawyer before you adopt a mark that you do find on social media and only find on social media. I think it's definitely something a lawyer should weigh in on. I think you should be cautious about promoting your anticipated use of a brand name publicly and on social media before you're ready to launch, because that window of time where you're anticipating use but you haven't used, and let's say you haven't filed a trademark application at the Patent and Trademark Office, that's a window of time where people can steal your brand name idea and can run with it. Anticipated use is not use, so don't run around telling a whole bunch of people, I'm gonna call my dispensary XYZ. Unless you filed an application at the trademark office, in which case, by all means, you got your flag in the ground, go ahead.
But on that subject, if what you're offering is a web-based service, then your use on social media or on your website could count as use. And in that case, you should also be careful about using the mark before you work with trademark counsel to make sure that mark is available, because you could accidentally be infringing someone else's mark, or you could make them think you're infringing their mark. And either way, whether they have a leg to stand on or not, they could come after you and it'll be expensive.
You guys sound like lawyers.
Yeah. I'd also be really cautious to not take my disputes to the airwaves. I think a lot of people feel inclined to talk about an instance of infringement or something they've seen online. And I think you have to be really cautious when you're taking to Facebook or Twitter. People are going to take screenshots. It can cause somebody reputational harm to make certain kinds of accusations. So you should be mindful. Reach out to a lawyer first if you think someone is infringing your mark, and see. They'll do some investigation. We'll poke around and see if that really is infringing, because you might end up shooting your mouth off and finding out that the other person's use actually predates yours, and now you're in a really bad position.
Right. Now you've been all loud about it and also wrong.
Yeah,
exactly.
Yeah, nothing worse than being loud and wrong.
Yep.
You remind me of, basically, really don't say anything. Is kind of, like Lenny Bruce, for instance. Do you guys know what I'm talking about? Was, in this tremendous lawsuit, and then just made his stand-up comedy act really not any bit of stand-up comedy, but just talking about the lawsuit. Do you know what I'm talking about there?
Right. Yeah, and I think if you're Lenny Bruce, you might be able to get away with a little bit more. You're still probably going to get in trouble.
Right.
I mean, it's a tough one. Like, we don't want to suggest that you just shouldn't say anything, because surely you should be out there promoting your brand and talking about your company and saying all the positive stuff you want to be saying in the public. But yeah, no, I don't think it's a good idea to run around and be really public about ongoing disputes and things of that nature. It's even worse, though, to be really public about things that you're not sure are actually, real things, like somebody infringing your trademark.
I think the best case scenario, if we're talking to our future clients out there, is that the minute you come up with a brand name or a couple brand names, a couple ideas that you want to use for your brand, you go to lawyers right away. You go to trademark counsel, someone who, not just any lawyer will do. You want someone who does have that IP background. A lot of lawyers will file a trademark application, but you really want someone who has the IP background. And in cannabis, you want someone who has an IP and cannabis background, because there are a lot of unique elements to that. But you go to them and you present them with 2 or 3 names, and you ask about availability, you ask for a risk assessment, and they will give that to you. That's what we do for our clients, and we can tell them, hey, this is a non-starter. It's not even worth doing a search. Or, yeah, this is great. It's a good candidate for a search. We're going to explore and find out more. And from there, you move forward. What you should not do is wait to come see a lawyer until you have decided on a brand, ordered all your packaging that contains your brand, ordered your letterhead, ordered all your swag. Don't do that, because it's a lot harder to convince yourself to rebrand, because you have the sunken costs fallacy. Even though, in fact, rebranding is almost always the better strategy if it turns out that the brand you chose is not really going to be clear. Because, we always joke, look, you could use this mark, but it's going to be expensive to protect, and you're going to pay all that money to us, so we're not complaining, but we would still rather you not. We'd rather you not waste your money fending off potential infringers or fighting off people who think you're infringing their mark.
Yeah, and that brings into, I think here we are in 2016, 2015, and 2014. We've got a lot of great players in the industry that really are starting to define extremely strong brands, unique, completely unique brands. There is an element of the industry, though, that kind of plays off of other well-established brands that are out there in culture. What is your advice to those that are engaging in coca cannabis? You know what I mean?
Our
what would you
advice
say
is
to that?
to cut that shit out right now.
Yeah. Stop it.
I mean, really, we're working to elevate the industry, right? Whether this is a cannabis rights movement or LGBT movement, like, we all need to act like professionals. And in this case, it's a business, it's an industry. We need to act like the professionals we want to be treated as. We call that, and we got this word from Susan Squibb, who writes for The Cannabis and works for Mary's Nutritionals. We call that Brandelism. And it's a problem.
Ooh.
Yeah, I know. She's good. Yeah, we've stolen that. It's a problem. Brandelism in this industry, it's getting better. And there's a lot of self-policing, policing within the industry that's been happening, which is great. But it's a problem. And it's a problem whether it's sort of intentional and obvious or not. One interesting thing about trademarks is, your trademark rights exist in connection with whatever goods and services you offer. So they exist in connection with what you do. So that's why you can have a Pandora that is a online radio station, an online music provider, and you can also have a Pandora that sells jewelry. And as far as we know, those aren't getting confused, right? Those are distinct.
Right.
People are not confused when they see the name in certain contexts. And generally speaking, that is the analysis that trademark lawyers do. Okay, someone else might be using a similar or identical name, but if their industry is distinct enough from yours, it's okay. There's kind of an exception in cannabis. There are two exceptions, I should say. One exception is with famous marks. You can't steal Coca-Cola no matter what you do. You shouldn't use Apple unless you're literally selling apples, But in cannabis, even if a mark isn't famous, we tend to assume that brand owners who have more wholesome brands, whether that be food or toys or just, household goods, anything marketed to kids or family, or just any kind of big brand, they are not going to like you getting anywhere near them with your cannabis brand.
Right.
And so we're a lot more cautious when we do that risk assessment for our cannabis clients. And we're considering, any possible similarities to existing established brands. And we tell them, look, we don't think cannabis is scandalous, but a lot of people still do. And you probably don't want to upset others unnecessarily, by going with this. And so our calculation does change a bit because we are really trying to get the industry out of Brandelism.
Right. I love Brandelism, by the way. And I do like the concept of, just at this point in time, folks, as far as going against existing traditional, brands, well, I guess you could say it's like opening Pandora's box.
But exactly.
All right, and we don't want to do that. That's if you've read about that, it's a bad thing.
Well, it's in so many levels. And in this context, you're already taking on a lot of legal risk and liability as a cannabis company. You don't need to add to that liability unnecessarily by, potentially infringing a non-cannabis company's mark. And Shabnam often talks about this. It's not fair use. People think that, oh, well, I can use it. It's fair use because I don't know. I don't even know why that people just say that.
They think maybe there's some sort of First Amendment protection. They think that it's like parody. A lot of people think it's parody, and parody is actually a really interesting animal in trademark law. It's not a complete defense. I mean, there's actually a bit of a divide whether or not it's even a defense, and it's maybe works its way into defending yourself in a different approach. But yeah, a lot of people think that it's, satire or parody and that they can get away with it because they're somehow sort of riffing on a famous brand. And it's not. The First Amendment doesn't play the same role in trademark as it does in copyright or in non-commercial speech, obviously. And so you have to be really mindful of that. Although we've seen some really interesting case law come down on this very similar subject. But so you can't. You just adopt Coca-Cola's mark to identify your infused soda you're going to get sued and Coca-Cola's going to win. That is an indefensible.
Yeah.
That's just how it is right now. That's what's going on. You bring up interesting case law, and I wonder, we've got the Cole memos basically to kind of reference in regards to finance for cannabis. What are your referential points for what you're doing in cannabis, understanding it is federally illegal, but it is absolutely legal in certain states?
We don't really have anything like that in trademarks. And it's actually interesting because a lot of people ask us, what do you need to sort of change what the U.S. Patent and Trademark Office is doing? And it's weird. The PTO is only going to do whatever is lawful under federal statute, under federal law. So we're not going to see, it would be unlike, we actually did see, there was this tiny little window of time where the Patent and Trademark Office just decided out of whole cloth to start issuing trademark registrations for trademarks where the goods and services indicate cannabis, like cannabis delivery or baked goods involving cannabis, something like that. That stopped in like a matter of days. Like it didn't take long before that was shut down. So we're probably not going to see the PTO randomly take some sort of action like that. And we're probably not going to see like internal, like a memorandum that kind of gives some more authority. It's just unlikely. It's not within the scope of the Trademark Office's authority to decide outside of what's lawful under federal law what they might grant a trademark application for. There's some wiggle room under, the use in commerce standard, and to sort of make some. There's a little bit of wiggle room for some sort of legal argument affecting something a little bit different than what we're talking about. But insofar as like, are we going to see a Cole-style memo that's going to make us believe there's a little bit more movement as to what the Patent and Trademark Office is going to do? No. We're waiting for the Controlled Substances Act to change. That's what will affect what's going on in the Patent and Trademark Office, and really nothing short of that. Having said that, unless something happens with use in commerce, and so we see an lawfully intrastate activity somehow qualify, like that prostitution thing, and then if we see
I think you're going to have to explain that prostitution thing.
If we see some wiggle room under use in commerce, because right now what our hang up is that because cannabis is cannabis, period, the transport of it, the manufacture of it, the whole bit is unlawful under federal law. The Trademark Office is like, listen, we can't grant you a trademark application because your trademark application necessarily needs to be supported by lawful use in commerce. And there is no way you can make lawful use of commerce of this mark in connection with these goods and services, i.e. the cultivation of cannabis. So let's say there was a way to get around lawful use in commerce, which in commerce, under Commerce Clause, we're talking about interstate commerce, right? Using some sort of a federal highway, the Federal Postal Service, from one state to another, things like that. So what if there was some wiggle room there? So long as your goods were lawful within a state, like brothel services are in Nevada, so you take that lawful service plus some wiggle room on use in commerce, and then you come up with a lawful way to get a trademark registration in the Patent and Trademark Office. But we'd have to see some case law develop under what the trademark statutes and then subsequent court decisions mean by lawful use in commerce. That's where we might see. It's not going to be a memo. It's going to be case law.
Well, and that's an interesting point, too. People frequently, there was some article written recently that says you can't get a trademark if you touch cannabis at all in your company. And we don't know who wrote this or where they're getting their information, but that's not true. It's not really even a logical sentence, but you could get a federal trademark registration even if your company involves things, even if your company distributes cannabis and that's technically in violation of federal law but still compliant with your state law, you can still protect the lawful aspects of your business, and that's what we do at the Trademark Office. Now, the thing is, we have not yet seen this tested in court. So a federal registration that a cannabis company owns covering its lawful services has not yet been tested in court. And so we don't know. We don't know what's going to happen if that happens. My God, would we love to be involved in that case, but we don't know.
Yeah.
We don't know what it's going to look like. And until then, what's interesting is that the reason I say you need to work with a cannabis-specific trademark attorney is that the best guidance we have, it comes in the form of office actions. where we file a trademark application, and the attorneys at the trademark office, and there are only 3 that handle cannabis trademarks, even though there are hundreds of examining attorneys. There are 3. We know them all, and they handle trademarks in cannabis. And sometimes you'll get assigned to a different one, and inevitably your application will end up getting sent to one of these cannabis examiners. And they are issuing detailed guidance that is in response to what you request. And, recently we've been seeing some wrinkles that I won't get into, but have changed the way that we're drafting goods and services. And, you really need to be kind of up on the very newest thing that's happening. And it's only coming out in these sort of letters to the applicant from the trademark office. It's not coming out in a memo that's, issued to everyone. You can see these online, but, you're not really going to spend your Saturday night. Well, I mean, maybe if you're us. I mean, but
You will. Yeah.
Well, we do. Don't judge. But you aren't going to go do that on the trademark office. That's what they pay us for.
Right.
Yeah.
And did you the wrinkles that you mentioned? You're not going to get into those wrinkles because that's your intellectual property, correct?
To some extent, yes. If you want to know, you'll need to call us.
All right. So I got it. So it's going to come down in case law. It's going to come down in a memo back to you about your trademark that you are trying to file. That all makes good sense. We've got the basics down. We've got the stay away from traditional, established brands. Is there kind of a third bucket of do this, don't do that? Can't you read the signs?
What was the first one again?
I'm not sure. One thing is, this is a business decision, but if you're a cannabis company and you want to protect your brand. I mean, first of all, in the United States, your trademark rights derive from your use. So the minute you start actually using, not just talking about using, but using your mark in connection with your goods and services. So if that's goods, that means once you start selling actual, brownies that are wrapped in a package, a child-proof package that has your brand on it, that's use. If you're offering delivery services, once you put up your delivery website and people start ordering from you, you're using your brand. So if you are a cannabis company and all you do is sell cannabis, you grow cannabis and you sell it, that's great. That may be all you want to do, and generally, that's fine. But in order to get your brand protected, you're going to need to build out some of those lawful goods and services that we talked about that you're going to protect. And we can help you. A lot of our clients, one of the things that they have, if nothing else, is a website that has a lot of information about medical marijuana. And that's a service. Offering that information online is itself a service that we can protect. But having more than that, maybe you cultivate cannabis, but maybe you also cultivate mushrooms. Or, I'm sorry, that was a bad example. I meant actual, regular, like in your salad mushrooms. But maybe I should have said tomatoes. Maybe you cultivate something that is lawful to be sold in commerce. Because that way, and we're not, sneaking. This isn't sneaky. This isn't wrong. This is just how we do it. We can protect at a federal level those lawful aspects of your business. So you do develop rights once you start using your mark in the state, in the place where you're using it. But in cannabis, that's really tricky. And Shabnam can talk to the sort of branching part of our business and and how we help people protect their rights in multiple states. But, one thing that's hard is, generally speaking, you've started using your brand. You may not have filed an application yet, but that's okay. You've started developing rights. But those rights are state limited. And when your actual business is necessarily limited to your state, you're a cannabis company in California, you better not be shipping your cannabis over state lines. But what if someone starts using the same brand in Colorado? You may not have rights to stop them because your rights are limited to California. And so we help you protect that.
Yeah, no, that is fascinating that you've got your inter or intra-state conflicts there. I'm all good in California, but look what happened in Colorado.
Exactly.
Well, the best approach is, like Amanda's saying, is to offer some federally lawful goods and services. And then the second way is what we do and lawyers like us do, which is help you identify some partners in other states that can be your licensees. So you license your intellectual property to them, and then they start manufacturing your goods in another state under your brand name, and then you actually get the same rights and your core services in that now sort of receiving state as you would in your home state. So the best way for a California, let's say, edibles maker to protect their brand for use in connection with infused edibles in Colorado is to license their mark to a Colorado partner who can produce and sell that product in Colorado. And then those rights go back to the California company. And there's obligations. This stuff isn't easy, and it's surely not cheap to get there. But once you're there, you can have a strategic partner creating quality products in another state and building out your brand for you, your trademark rights for you. And it's a terrific way to become a national cannabis brand.
Yeah, and that's obviously what a bunch of folks are doing, and there's many reasons for doing it, and one is to protect your intellectual property right there. All right, so you guys, I don't want you to give away the store here, so I'm going to stop with all those questions, and I am going to focus on the three final questions, and I'll let you know what they are, and then I'll ask them, and we'll go person by person. So the three final questions are: what has most surprised you in cannabis? Okay, we're going to ask Amanda that. What has most surprised you in life? We're going to ask Shabnam that. And then we're going to ask both of you on the soundtrack of each of your lives. Name one track, one song that's got to be there. So Amanda Conley, what has most surprised you in cannabis?
How much people love lawyers. It's amazing. It's an industry, and I'm speaking to California really here because that's where we are, although we do represent clients all over the country. But we're well networked in California, and man, I go to events. I literally was I was standing at an event a few months ago, and I was talking to someone, and I was talking about trademark law like I do, and I literally got gently accosted, and someone said, "You're a trademark lawyer? I've been looking for a trademark lawyer." It was like, yeah, this totally happens all the time. Whereas I spoke on, in our previous lives, and still to some extent we do, tech law, and I spoke at South by Southwest on gaming and intellectual property, and I was all excited. I'm going to go down here and network, and I'd been having such a good time networking in the cannabis industry, and I would be chatting with someone. They're like, "What do you do?" And I'd say, "I'm a lawyer," and it's like they would just walk away. I mean, it was so shockingly different.
Well, and I kind of spoke to that before when I said, kind of general society for some reason has an issue with lawyers, but definitely not in cannabis. Cannabis, I mean, lawyers are at the top, definitely.
Yeah, no, it's wonderful. I mean, we have just been so well received. We were nervous. We're in a state where there's been an industry for so many years, and we didn't want to seem like, hey, we're going to come try to capitalize on this. We wanted to learn and wanted to support and, meet people where they were, and we have just been so well received and loved, and I doubt very many lawyers can say that.
Yeah. You just pointed out something, and we started doing work in cannabis in 2013, and there definitely was a sense of hey, don't just come in here and try to make a bunch of money. That has completely changed over the subsequent 2+ years. 2016 is a completely different story as far as getting in for commerce. But anyway, Shabnam, what has most surprised you in life?
I've been thinking about this while Amanda's been talking. I totally agree with her, by the way, on what's most surprising about cannabis. I think that what's most surprising about life is that what actually my recent work, this work doing with Amanda, has shown me is that your story never ends. Law was a second career for me. Being a cannabis industry intellectual property lawyer is like a third career for me. And I think what's interesting is you just never know when things might happen for you. And for me, having found Amanda and our partnership, it's really I'm totally getting emotional. It's really having found, I'm married. Okay, so setting aside that I found a spouse, having found Amanda has been finding my intellectual and my creative partner. And I always wanted Amy Pollard, what's her name? Tina Fey partnership.
Tina Fey,
yeah, I wanted my professional sort of yin and yang, someone I could be creative with, someone I could launch companies with, someone I could think with, and really build something that was was fulfilling in a different way than my romantic partner. And that's really exciting for me that I found that now. I was a lawyer for 10 years. Like I said, this was the second career for me. And it's just been incredible. The partnership that Amanda and I have and what we've done with it in the past almost 2 years now, and our relationship dates back farther than that. But it's just been really incredible. It's been life-changing for me. And, I'm in my early 40s. It's really, just meant something totally different and new to me. And I've always enjoyed the careers that I've had and been very career-minded. But I have to say, this is, really changed things for me. It's changed my life, and I love it. And I think that this partnership and finding it in my 40s has been something that's really surprised me about life. It's great.
There you go. It's not a destination, Shabnam. Life is a journey, and so that's a great answer. And thank you for that, Amanda. Do you have your track? Do you have your song on the soundtrack of Amanda Conley's life?
This made me so nervous, in part because I wanted to reference my playlists, but my music player of choice, Rdio Radio without the A, was just acquired by Pandora, and so I can't access them anymore. Although, in Rdio's defense, they are accessible. They're just on a zip file somewhere. But I was thinking about it, and actually, I think it's going to be a Melissa Etheridge song.
Oh my God, really?
I know, because when I was 12, maybe 11, I would always rock out to the song If I Wanted To. It's very empowering, probably not one that everyone knows, but I think If I Wanted To by Melissa Etheridge would definitely make my life soundtrack.
There you go. That's fantastic. As I told her, as we discussed, the one that I associate with her is I'm the Only One, because it's got that kind of bluesy type of thing. But we got to check out your selection, and thank you for that. Shabnam, do you have one?
Yeah, my song, it's completely different than Amanda's. My song that I would take, one of 5 that I would take to an island with me, is really dreamy, and I get to zone out to it, and it's been on my list of songs I would take to an island with me for years, as long as I can remember. And it's This Must Be the Place by the Talking Heads. I just love it. It's ethereal, and I zone out to it, and I just love it. And it is very much like the soundtrack of my life, which is spending a long time zoning out or trying to find time to zone out. And yeah, it's just a beautiful song, and everyone should take it to an island with them.
Talking Head, is that on 77? No, that's not on 77.
It's on Speaking in Tongues. I'm looking at it right now, actually.
There
and it's
you
really
go.
funny because I'm not generally a huge Talking Heads or David Byrne fan, but it turns out my husband is huge. So it's just really funny, actually, that one of the songs that I would take to an island with me happens to be by a band that my husband's been following for years, goes to see David Byrne whenever he can on tour.
So maybe you'd take your husband to that island.
That's
for another podcast. Just kidding.
Look at that. Well, and then as far as your husband is concerned, I'm sure he knows that the Talking Heads started out at CBGB's in New York City. And just to connect all the dots, you can let him know that I back in the day did some shows, produced some shows, because I don't play any music. I have no talent whatsoever, but I produced some shows at CBGB, so you can let your
that's
let
really
your husband
funny.
know.
That is really funny. I'm also a talentless. I was a talentless sound engineer. I can't play an instrument to save my life, though I do sort of know how to play the piano and the bass. But I sound engineered for bands, so maybe that's a thing that us, those who lack talent, then get into the production side. That's really funny.
Shabnam, I appreciate what you're saying here, but you said I have no talent, but I know how to play these 2 instruments.
Well, not really
I feel like
I mean, I don't actually know how to play them in a I can play 2 songs on the piano type of thing. But I didn't want to say I'm completely devoid of talent. But yeah, so
2 songs. Fair
enough.
I mean, For Elise and the Imperial March as of.
For Elise is a hard song, though. That's
it's kind of one of those everybody learns it when you learn piano. Yeah. See, there you go. Amanda, one of the 2 songs Amanda can play, and the other one I learned 2 months ago. So.
Well, listen, Amanda Conley, Shabnam Malek, thank you so much for your time. You schooled us a little bit, also in some IP, so we appreciate that. And as 2016 goes, we'll check back in with you and see what your thoughts are as things change. How about that?
Perfect. Thank you so much, Seth. This was a lot of fun.
You got it. All right, guys.
Take care.
Bye-bye.
Amanda Conley, Shabnam Malek, Brand and Branch. Great conversation. Really appreciated getting to know their two very unique stories, unique to the general populace, unique to each other, and really appreciated the advice that they gave on IP. Amanda and Shabnam.